Thanks for inviting me to today's session. It's never too early in the morning to begin with some law. And so as advertised, I'm going to focus on some of the legal issues that have arisen recently in relation to privacy and surveillance. I've entitled my talk, as the slide suggests, somewhat tongue-in-cheek, "Does the State Belong in the Computers of the Nation?" So just to cut to the chase and give my response, yes. There are absolutely circumstances where the state should have powers of surveillance. Nothing separates communication by electronic device from the sort of important policy concerns and considerations that justify carefully controlled and overseen state surveillance. And those policy concerns are often compelling. Not least, there are bad people who would do us harm. And anticipating and preempting their conduct is often our best defense. That requires intelligence, and intelligence often depends on surveillance. But everything hinges on my caveat: carefully controlled and overseen. And so let me explain, in using these terms, of what I am speaking. I am focusing on what I'll call privacy 1.0. The idea that the best protection for privacy comes from supervising and limiting the data that government can collect in the first place. Now, as an aside, I think we need to have a more profound conversation about what I'll call privacy 2.0, what the state can do with data already in its possession. But I'm going to focus the conversation this morning on privacy 1.0. That is the control of collection, the gatekeeping function. And on this issue, for a surprisingly long period of time, the rules governing intercept of computer-based communications have been murky, part of that creative ambivalence, if you will, that was mentioned moments ago. Mostly, this ambiguity stems from a mismatch between modern electronic communications and laws designed for a very different age. Now, this disconnect has created ambiguities that have been both a source of uncertainty, but also of creative state interpretations of exactly what it is they're legally able to do. To the extent Parliament has intervened, it has generally done so in pursuit of clarity at the expense of privacy. However, in the last 18 months or so, the Supreme Court has entirely recrafted the legal landscape in a manner that makes much past practice and legislative projects irrelevant. Put more concretely, the court has signaled that that phrase, carefully controlled and overseen, still has a place in assessing the legality of state surveillance in the computer era. And so in the next 10 minutes, what I'd like to do is set out briefly where we've come from in this area, where we are now, and then suggest where we may be heading. My focus will be mostly, although not exclusively, on national security-related surveillance. So, where have we come from? In the area of security surveillance, privacy law has generally not kept pace with two key developments. First, the considerable overlap between what were once the fairly discrete areas of criminal law investigation, security intelligence investigation, and foreign signals intelligence collection. And second, they've not kept pace with the technological communications revolution. Let me trace, albeit very briefly, and hopefully have this work. There we go. Let me trace very briefly then the development in law and surveillance. And I'm going to start with an act promulgated by Parliament in 1974 called the Protection of Privacy Act, now known as Part 6 of the Criminal Code. Part 6 is the most important of what we call lawful access provisions. Part 6 makes unauthorized intercept of private communications a crime. In practice, and subject to certain limited exceptions, lawful access therefore requires judicial pre-authorization. Judicial blessing in advance of interference with a reasonable expectation of privacy has since become the standard under Section 8 of the Canadian Charter of Rights and Freedoms. And the practice for judicial authorizations of all sorts in privacy matters has been specificity. That is, warrants are issued for finite purposes against finite targets and in finite circumstances and locales. Part 6 was and is directed principally at law enforcement. It is the means by which the RCMP, for instance, receives wiretap authorizations. That said, the principles undergirding Part 6 and its lawful access provisions, that is, advance authorization by judges providing warrants with specificity, those principles also became part of the regulatory system for the Canadian Security Intelligence Service, for CSIS, when that body was created in 1984. There were, however, and there remain, differences between criminal law surveillance and the security intelligence surveillance conducted by CSIS. For one thing, Part 6 surveillance authorizations must ultimately be disclosed, both their particulars to the person who has been subjected to surveillance and also annual statistics on the number of such measures. In practice, the annual number of CSIS warrants do appear in the CSIS review body's annual reports. However, existence of CSIS warrants is not disclosed to the targets and only comes to light in the rare instances where a CSIS investigation morphs into a criminal matter and is passed on to the police and then culminates in criminal charges, or even more rarely, when a particular CSIS surveillance operation becomes a matter of public controversy. Canadian law, in other words, places criminal law surveillance and security intelligence surveillance on different legal footings when it comes to transparency. Then, in 2001, after 9/11, the National Defence Act was amended to codify formally the intercept powers of Communications Security Establishment Canada, CSIC, although I'm told this morning that we're reverting back to the old handle of CSE. Now that I've formally trained myself to say CSIC, I have to revert. Of particular note, this new law opened the door to lawful intercept by CSE of Canadian private communications as part of its so-called Mandate A, that is, collection of foreign signals intelligence. Up until this point, had CSIC or CSE intercepted a Canadian private communications in performing its foreign intelligence function, it would have committed a crime under Part 6 of the Criminal Code. After 2001, CSE was exempted from Part 6 so long as the Minister of National Defence authorized any intercept of private communication. Now, obviously, the fact that the authorization comes from a political minister and not a judge places CSE on a fundamentally different footing than the police or CSIS. Moreover, unlike CSIS or Part 6 authorizations, CSE authorizations are more generic permissions relating to an activity or class of activity, and not to specified or specific individuals or specific undertakings by those individuals. And in terms of transparency, the CSE review body tells us how many ministerial authorizations exist on an annual basis, but we know nothing about their content, which remains a closely guarded secret. These differences in the CSE lawful access regime likely reflected the perception that CSE's eyes were and are outward-looking, focusing on foreign signals intelligence that only incidentally and haphazardly sweeps up domestic communications. Conventional privacy protections could, in these circumstances, be muted. Much, of course, has since been said and debated in the post-Snowden period as to what CSE does and does not intercept, and how and in what circumstances it captures private communications. I'm not going to rehearse that saga here. Instead, let me just make my key point. Since 1974, the scope of lawful access has gone from, first, police investigating crime and intercepting with specific judicial authorization that is then subsequently disclosed, to second, CSIS investigating security intelligence matters and intercepting with specific judicial authorization that is never disclosed, and third, CSE collecting foreign intelligence by intercepting private communication, at least incidentally, with more generic authorization, not from an independent judicial officer, but from a member of the political executive that is never disclosed. In the result, we have a system of surveillance law designed for a criminal law paradigm, tweaked to deal with security intelligence and essentially abandoned in all material respects for foreign signals intelligence. This may have been sustainable in a world partitioned neatly into three categories of criminal, security intelligence, and foreign signals intelligence. However, since 9/11, national security and specifically anti-terrorism concerns have become increasingly hybridized. Criminal, security intelligence, and foreign intelligence matters. In actual surveillance practice, it is apparent that the foreign intelligence, security, and crime boundary is murky. For instance, there has been some controversy in the past between CSE and its review body as to whether some of CSE's activities truly amount to foreign intelligence gathering. Now, that particular concern has since been resolved, but more recently, additional controversy over CSE's metadata collection activity reflects a second notable development since the 1970s: how technological change has undermined a privacy regime first constructed for a simpler communications age. By all reasonable accounts, metadata, especially when pooled with big data, can be even more revealing of human behavior than even intercepted communications content. Yet the government seems regularly to take the view that metadata is not private communication as a legal matter. Now, I disagree with this particular legal opinion in an article of 12,000 words or less that will appear in due course. However, to the extent that this position animates inside government approaches on the issue, it has the effect of making the privacy protections of Part 6 irrelevant. Indeed, under this reasoning, CSE doesn't even need a ministerial authorization for its metadata intercepts. In the result, we have intercepts of potentially revealing information with no advanced judicial or even legally mandatory ministerial oversight, and no formal disclosure requirements of any sort. So what has happened recently? Well, over the last 18 months, the Supreme Court has begun to reclaim lost legal ground, resurrecting and reasserting established rules on search and seizure and underscoring their relevance in the cyber world. Three cases serve as a sort of trilogy in this area: Telus, VU, and most recently and most importantly, Spencer. We're also expecting a fourth case imminently called Firon on searches of smartphones. For reasons of economy, I'll focus on Spencer, a decision with which I'm sure many of you are familiar. To cut to the chase, Spencer was about internet subscriber data in a police child pornography investigation. The information in question was the name, address, and telephone number of the customer associated with an IP address. It was, in other words, the most benign form of data attached to an IP address, what some have called mere postal envelope information. In a nutshell, the court nevertheless held that the Charter's Section 8 protections against unreasonable searches and seizures extended to this subscriber data. If the police want it from a service provider, they need to come a-knocking with a warrant. The court was unmoved by the fact that the information was actually in the possession of a service provider, that is, in the hands of a third party, and there was in fact a service contract that, at least ambiguously, suggested disclosure was a possibility. Didn't matter to the court. Because of all this, I regard Spencer as one of the most important privacy decisions made by the Supreme Court, bar none. So let me provide then, to round out this talk, some thoughts about what all this may mean for the future. First, the Spencer holding has obvious knock-on effects in the legislative arena. For one thing, earlier proposals spearheaded by Vic Tays when he was public safety minister permitting warrantless access to subscriber information, those sorts of proposals would now clearly be unconstitutional. There are also secondary issues with law projects before Parliament now. For instance, Bill C-13, the so-called cyberbullying bill, has now moved to the Senate. It contains warrant provisions for metadata, which it calls transmission data, albeit warrant requirements that require relatively little of police to obtain. But it also purports to allow law enforcement to continue to ask for voluntary disclosure by service providers, something that would almost certainly violate the constitutional rules outlined in Spencer. And it then purports to immunize those service providers who do cough up that information. Now, the question's a novel one, but it is quite plausible that those immunity provisions would fail on constitutional grounds if challenged in court. And so any service provider conscious of its legal exposure should respond to a state request for subscriber data with something along the lines of, please show me your warrant. Second, I think there are obvious implications for security surveillance by CSE. The Supreme Court is prepared to extend Section 8 protections to the most benign data, name and address and telephone number associated with an IP address. It is inconceivable to me that it will now demur when it comes to other, even more intimate forms of metadata created by modern communications. Geolocations, place called, duration of calls, websites surfed, etc. The degree of privacy protection will always depend on the circumstances, but I think the constitutional die is now cast when it comes to the sort of metadata most contentious in the post-Snowden debates. We don't know, of course, what CSE and perhaps other agencies have in fact been collecting under the umbrella of metadata. But the concept is so broad and Spencer so dramatic that I assume at least some of what the government has in the past collected is now subject to the full protections of Section 8. And so putting CSE's activities on a sounder constitutional footing will require amendments to its governing statute. And in that respect, I strongly support the private members bill tabled by Joyce Murray, Bill C-622, now reaching second reading in the Commons, that would, amongst other things, graft a modified judicial warrant regime on CSE activities. So let me conclude then by reverting back to the question that lies in the title of my presentation. Does the state belong in the computers of the nation? My answer was yes, but subject to careful control and oversight. The Spencer decision has breathed new life into Privacy Law 101, that is the intercept gatekeeping rules. And I think it is important to now ensure that control and oversight by courts becomes part again of the entire contemporary world of state surveillance. Thank you very much.